Good afternoon, everybody. So if we could resume. So moving on to some of the specific questions that are posed about the Hazelmere site. So following our earlier hearing sessions, the council undertook to provide further evidence where available on two sites. So these were sites DS01, the Hazelmere Quay site, and site the S07 Fairground car park. So taking the DS01 site firstly, the Quay site, could you please outline the updated position on that site, please, Mr. Begler?
So yes, I'm going to hand over to Mr. Longley for these ones.
Thank you.
Thank you, sir. Yes, in our response statements on page 6, we provide an update insofar as we're able to on these two sites. With the Hazelmere Quay site, I suppose the summary at the bottom of the page is probably all the need to draw attention to at this point, which says that the development potential has long been recognised of the Quay site, and in LPP2, the council has committed to a more proactive approach to bringing forward a comprehensive scheme. There's active development interest in part of the site already, and we've provided the marketing material that was put out as part of the sales of that site. And we do so not saying that that is necessarily going to be acceptable in the form that it's shown, but to show that there is clearly development potential on the site and in the periphery of the site in particular, where there are some lower quality buildings. That scheme is for a mix of uses, and it does include a number of dwellings, a relatively small number of dwellings, but it's clear at the moment that's largely because they're looking to dip below the affordable housing threshold. So all I'd say is that there is clear development potential. The council was keen to acquire that part of the site, but we understand it's under offer to other parties. But the council will work very closely with whoever acquires the site to bring forward a scheme that contributes towards the housing numbers that we've identified in LPP2. And we think that 30 dwellings across the whole of that 2.5 hectare site is developable in the plan period to 2032. And we've been relatively cautious in putting those 30 dwellings towards the back, right at the back end of the plan period, recognising that the complexities are on a mixed use development. But clearly, if a proposal comes forward sooner, then those completions can be accelerated.
Thank you, Mr. Longley. So in terms of the feasibility study, that was included as an appendix to the hearing statement. So who produced that, and what was its intended audience?
I believe, sir, that was produced by architects on behalf of the two owners of the land in question, and the intended audience was presumably the commercial market in trying to attract an enhanced value for that piece of land by showing its development potential.
So on that basis, I mean, what indications are there that the prospective owners of the site are looking to develop it rather than manage whatever there, whatever's on site currently?
I think so. When you see, you've no doubt seen the site already, but that the area of the site is in part occupied by lower quality buildings that aren't particularly contributing to the townscape. And I think we're aware that the offer that has been made is based on achieving planning permission. So they are clearly envisaging it as an investment opportunity and a development opportunity rather than to sit on a piece of relatively scruffy land at the edge of the quayside.
Okay, thank you, Mr. Longley. Mr. Banner.
Good afternoon, sir. In relation to this site, just a few comments. Firstly, in terms of what was said a few moments ago and in the council's latest matter statement on this, ultimately, I suggest it's just not convincing an explanation as to what's changed, bearing in mind this is a dinosaur site that's been allocated, I think, for longer than the entirety of my career. Certainly for a very long period of time. It's not convincing. It's more in the nature of assertion and hope rather than clear evidence or indeed any real evidence. That's the first point. Secondly, there's not really any detail of any level explaining how the fragmented ownerships has been resolved. An offer's been made, we're told, but for which parts of that site, bearing in mind what you've heard already about the fragmented ownership. In relation to the study, the feasibility study, I think it's called, that you asked about, I have a few observations on that. I think, if I remember right, it's Appendix 7 of the council's material. I'm just going to get that up. Firstly, I ask you to note at 1.2 of that document, it's Appendix 7 of the Council's Matter 2. It's expressed in very high-level terms, which reflects the nature of the documents. An initial feasibility sketch, approximate schedule of potential for floor areas, initial concept design stage. So clearly, there's quite a lot more work to be done, and that's important because that goes to the feasibility and viability of the scheme. It's not simply a matter of, oh well, it's got planning work to be done generally, because you would expect allocation would have planning work to be done generally before they come forward. But this is a problem site, and you've got to be convinced that there's light at the end of the tunnel for those problems. And this document doesn't provide you with that confidence. There's further issues, because if you scroll through it, it's a very, very high level. There's very little text at all. There's no costing, no consideration of whether the sketched out development is in fact something which would be viable, bearing in mind a number of things, including land assembly, including the existing uses and use values. And also, if you turn to page 12 of the document, you see the approximate area schedule, you see the kinds of uses. And it appears to be common ground that any residential development of this site would be as part of a mixed-use redevelopment. And there's no analysis of whether those specified uses said to enable the residential development were viable and feasible at the time, and how might they have been affected by the pandemic, bearing in mind the extent of shops, A3 and serviced office floor space. A3, of course, being impacted in terms of the daytime economy if people are working from home more. And the artisan element seems rather novel. And again, no analysis of whether that's actually, there's a demand for it, whether it be let, whether it be viable. So there's a huge number of questions left begging. And so I would suggest that the points we made earlier, which I won't repeat, but the points we made earlier in the summer remain valid, and this doesn't provide an answer to them. Thank you.
Thank you, Mr. Banner. Are there any other points on the Hazelmere Quayside before I go back to the council? Okay, then Mr. Beglin or Mr. Longley, have you got any responses to Mr. Banner's points?
Yes, so just briefly, as I said, we've included that feasibility study to show you that there is active development interest on the site. And as I said, the council itself submitted a bid for the area of land in question, which is the area covered by that feasibility study. I entirely accept that a developer will want to come up with a viable scheme, and the pandemic may have changed it. And I would suggest that, if anything, that will have switched the emphasis more towards residential uses in a thriving market town such as Hazelmere, if indeed retail uses are less viable. But that's really for the second guessing what scheme will come forward. But I think the point we make to you, sir, is that the site clearly does have development potential. It has certainly been in the council's thinking for a number of years, but it does appear now there is interest coming forward, and the council, through LPP2, has indicated that it's willing to take a more proactive approach, including use of compulsory purchase, if that helps speed a development forward.
So in effect, the policy in LPP2 supports, in principle, using land assembly powers should it be necessary, Mr. Longley?
It does, sir. I'll find the word, and I'm sure I haven't imagined that part of it. Yes, so it's in the description on page 144 on my copy, where it's describing the site. It says the site is in multiple ownership, and the council will work with other landowners to unlock the potential of this site, making use of compulsory purchase powers if necessary.
Thank you, Mr. Longley. Mr. Banner.
I mean, so just a quick one. I mean, obviously the prospect of CPO, which the council accepts may be needed to deliver this site, casts further doubt. I mean, plainly, it may very well be that there's opposition to the principle of the CPO. Landowners may suggest that they can deliver something alternative themselves. And it's not uncommon, of course, for landowners to hold out to the death anyway in the hope of better compensation. So that adds further to the delay. It also chimes, sir, with a theme that Mr. Neame, I and others made at the previous sessions, which I want to come back to later today in the context of Dunsfold 2, which is the need for sites that deliver early in this plan. There's an awful lot of backloading in this plan, and that should be a matter of real concern for you as to its soundness. And the very few sites, and certainly not nearly enough, that are truly oven ready to deliver quickly. But I might come back to that in the context of Dunsfold for obvious reasons.
Thank you, Mr. Banner. Any final points specifically on this site, Mr. Longley?
Only in relation to the phasing. We've, as I've said, we've phased the development in 2030-31 and 2031-32 to allow for complexities around compulsory purchase if necessary. But clearly, if a scheme comes forward in advance of that, which the council would encourage, then those dwellings will be developed earlier. But we have taken a cautious and realistic approach to the trajectory.
So if we can move on to site DS07. So in terms of that site, to what extent of the latest submissions that have been put forward by the council added any further weight to the case that this site will be developable for the purposes of the framework?
So this one is a bit of a dilemma, because the council is very actively involved in progressing proposals, but there are very strong commercial confidentiality reasons that we can't reveal more of those proposals at this point in time. I think what I've set out on page 7 of the statement is as far as our estate colleagues were happy for us to go in trying to convince you that a scheme is being looked at. It does include the quantum of residential development that we're indicating in LPP2, and it also safeguards a significant level of car parking, which I think was an issue that you also questioned us on. So other than what we've set out in the report, which I accept is perhaps not as full as you would wish, but or as we would wish, but at the point in the process we're at, it's the most that we can set out for you, sir.
And I take it that a cabinet paper is due on the proposal at some point. Is that correct, Mr. Longley?
Yes, so we've been advised that that's scheduled for the October meeting of the executive to update them on progress.
And would that be a public item, Mr. Longley?
I would need to check that, sir, if it's related to those matters of commercial confidentiality I referred to. Possibly not, but we will confirm that if that's acceptable.
Yes, please. Mr. Banner.
Essentially the same points as before, sir. Uncertainty, lack of sufficient specifics given where it is in the trajectory, and not sufficiently convincing. The other issue, sir, which I think is important to note, of course, the problems with these two sites are more than the sum of their parts, because the council's relying on two sites within Hazelmere, which are backloaded, as I've said, in relation to which the evidence is precarious at best. And I'd suggest one is bad enough. Two creates a real risk that needs in Hazelmere specifically won't be met when they need to be met. Thank you.
Thank you. Mr. Longley, anything further to add on that?
And only, sir, and be a point you're well aware of, that we're indicating that these sites are developable, and that in order to meet the definition of that, they're in a suitable location, which clearly they are, both in a suitable location, and with a reasonable prospect that they will be available. They are either wholly or mainly owned by the council, so clearly it's within the council's gift to bring them forward, and could be viably developed at the point envisaged. Well, in both cases, but particularly on the fairground site, there's active commercial interests, which I suggest wouldn't be present if there wasn't a viable scheme to come forward.
Thank you. So moving on to the Royal Junior School site. So I've had an update on the Section 106 application. Is there anything further to add at this juncture, Ms. Hawkes?
Yes, sir. Just to bring you completely up to speed. Can you hear me okay, by the way?
Yes.
Yeah. Jolly good. All of, as we set out in our statement to you, responding to the questions, all of the required outputs from Surrey County Council Highways have now been addressed, but we are now at the point of final detailed refinements to satisfy the council's highways authority. The highways officer has agreed the principles and the design of off-site works. They are satisfied with the proposals that we put forward in terms of the 20-mile-an-hour speed limit and virtual footway scheme, and that these can be secured by way of condition and would be implemented at the school's expense. In terms of the finer details, which are currently being negotiated, is in terms of the detailed workings of an automatic number plate recognition system. We're currently working closely with the highways officer and with the school to address the final outstanding requirements of the highways officer. The case officer, planning officer for the application, has been kept fully up to speed with the discussions that have been taking place. And she has advised me that the application is on the draft agenda for the council's planning committee, scheduled for the 12th of October.
Okay, and in terms of the phasing, if that were to be approved, what are the implications then for moving the school over to the Farnham Lane site?
We're looking at September 2023 in terms of the school moving over.
Thank you, Ms. Hawkes. Any further further points on the Royal Junior School site before we move on?
So I think I'd just emphasise what Ms Hawkes said, in that the move is scheduled for September 2023, and that move is not reliant on this section 106 being secured, as was promoted by United Learning at the last hearing sessions.
Thank you. So just before we move on to item 4 on the agenda, which focuses more on the housing trajectory specifically, I just wanted to go back to Mr. Wood to see if he's had confirmation on the dwelling numbers for the SANG.
Yeah. Thank you, sir. Yeah, I've gone back to check. The SANG 4.5 hectares will provide capacity for around 234 dwellings. And the planning application for the site, which has gone in, as you're aware, is for 216 dwellings.
Thank you, Mr. Wood.
Thank you.
Okay, so moving on to the housing trajectory matters. So I intend to take some general views on the council's updates in relation to the housing trajectory and related material. And in opening this topic, I want to set out that I'm now fully familiar with the Secretary of State's decision on the UK oil and gas application, with the council's position at the inquiry on that application, that appeal, sorry, and the subsequently expressed intentions to mount a statutory challenge to that decision and relevant parties' views on those matters. So I'm not going to be asking any further questions specifically on those points at this juncture. However, I'm mindful of recent news regarding the anticipated transaction of the site, and following this, a further update has been provided by Bidwells, which is an appendix to the council's hearing statement. So just to open the discussion on this, Mr. Beglin, is there anything further to add on that point?
So I think I'll pass over to Mr. Longley again, but you've had the benefit of seeing Appendix 6, and you see the level of detail that's contained in there in terms of the current activities that have been taking place in order to ensure that the site can be developed out in a way that accords with its positioning within the council's trajectory.
Yeah, so very quickly, the statement that has been provided by the promoters, by Bidwells on behalf of the promoters, does exactly as Mr. Beglin has said, is show that there's been no let up in the urgency and pace of preparation of the applications and reserve matters and discharge of conditions in order to allow this scheme to come forward. The only point I would pick up with the statement is that upon rereading it, I noticed the very last paragraph, there is a typo where it talks about reserve matters applications will follow the initial Q2 2024 residential RMA submission. It should actually read Q2 2023 residential RMA submission, and that's as per the penultimate paragraph on the previous page. I did go back to Bidwells, who confirmed that that is in fact a typo, and I've provided an updated version which we can put into the examination library in place of this one.
Yes, please, that'd be useful if it could just be annotated that it's where the error was, so it's clear. That'd be useful to me. Yes, thank you, Mr. Longley. So in terms of that that appendix, so it refers to Dunsfold Airports Limited being an experienced developer. So in what sense is it an experienced developer? Is it an experienced residential developer?
I think so. I'd need to take further advice on that insofar as schemes that they've been involved with. Clearly, they are, as part of Trinity College, experienced at bringing forward major schemes. But insofar as actually master developing, I would need to seek some further input.
Thank you, Mr. Longley. Mr. Neame.
Thank you, sir. I will endeavour to be swift, and I will also endeavour to not tread on ground already covered. And I'm grateful to Mr. Longley. He's removed one of the points that I needed to cover, so that's one less to deal with. But if I just stick with Dunsfold, I've got some other points on the trajectory more generally, but presumably you prefer if I come back to those separately. Right, okay, so just sticking then, sir, with the council's statement and Appendix 6, and I'll run through as quickly as I can. We're clear, I think, in terms of page 5 of the council statement, that the council is wholly reliant on the Appendix 6 statement. In terms of that is its evidence presented to you in terms of the deliverability within the 5-year supply and the developability beyond the 5-year period of the Dunsfold Park site. That appears to be the only reference within that evidence that you have. So we need that context in mind. We are wholly reliant on what Bidwells are telling us. The council have not undertaken or provided us with anything else. So we can also see then, if we look at Appendix 6, that the Bidwells document follows directly a request made by the council for further information. We'll see, sir, then as we start to move through the document, and I'll make the points one by one, that there is reference to a planning performance agreement supporting the deliverability and the timetabling. So this is somewhat of an old point. The PPA on this site's been in place for some time, some period of years. It's a PPA that does not contain a programme. And it's not dissimilar to other strategic sites within Waverley where PPAs have been in place. So I would suggest that you treat that with a degree of caution in terms of supporting the position that the site is in some way more deliverable than a site without a PPA. So we have a confirmation that the sale's fallen through. So Columbia Threadneedle, the development partner, is no longer progressing. And Sarah, as you'd raised, my question number one related to Dunsfold Airports Limited and their experience as a master developer. The reason I raised that question, of course, is because Dunsfold Airports Limited is, as we know, a wholly owned subsidiary of Trinity College. It is a limited company, an SPV company set up specifically for this purpose, namely to deliver this site. So I question, sir, where the experience in this company lies in terms of being a master developer, bearing in mind that it has been established for the purpose of delivering this site. We also know that there isn't a developer on board now. That development interest has fallen away. If we carry on then through the note, we're given a planning update, sir. That update doesn't actually tell you anything more than you had before you in July. In fact, I don't believe that it tells you a great deal more than you had in terms of evidence prior to that, in terms of the initial Matter 6 hearing session. So we can take that as read. It doesn't really provide you with anything else. If we then look at the issue in terms of infrastructure work and the suggestion, well, it's okay because the access road is going to be implemented and matters are moving forward. There's a lot of questions in this. For example, who is the contractor that's been appointed for the phase 1 works? Clearly, we had a previous statement, if you'll recall, sir, back in July, that these works would start conveniently just after the close of the examination in August. Those works, of course, didn't start. We're now being told that they will start just after the close of this session at the end of this month, the 26th of September. I would question how reliable that is, bearing in mind past history on this site. Where's the build programme that's referred to? We're not provided with that. Who are the house builders that are involved in the discussions? What level of discussions have taken place? There isn't any evidence before us to confirm that. What is the degree of interest? I'm grateful for the clarity on the RMA application. So we can take it that it's intended to be Q2 of 2023, and I'll come back to that on a programming point, sir, in a moment. But we do need to consider the realism here, sir, in terms of timetabling, in terms of what you've been asked to accept as realistic. So what you've been asked to accept as realistic, sir, is that the first phase for residential development will commence with an RMA application in the second quarter of 2023. And you'll see, sir, that midway down page 4 of the note provided by Bidwells, penultimate paragraph, we have a suggestion, therefore, that construction could begin realistically in Q2 of 2024. So that's a 12-month period by my mathematics for the processing of the first phase RMA to enable construction to commence. Now, first problem arises there, and it goes back to the original point that I raised about the PPA. And conveniently, we have Milford Golf Course, which we've heard an enormous amount about today, a similar site with a PPA in place. And the timetabling for the Reserve Matters application, sir, on that particular site, the application was submitted on the 2nd of July 2019, and it was determined on the 19th of November 2021, 2 years and 3 months. And so from my experience of dealing with multiple planning applications in this borough, that's not uncommon. But yet we're being asked here to accept, without question or corroboration, that the RMA will be dealt with within 12 months. Even assuming that is dealt with within 12 months, we're also then being told that 120 dwelling completions will take place in the 2024-25 monitoring year, bearing in mind that they say construction won't take place or start until the second quarter of 2024. That leaves us with a maximum of 6 to 9 months, which mathematically is, to coin a phrase, going at some for a house builder or house builders to deliver that level of completion. Simply unrealistic, simply uncorroborated, not clear evidence. Now, Bidwells, of course, actually accept that their note actually refers to them relying on broad assumptions, which is reasonable. That's the final paragraph of page 4, bearing in mind what I've just rehearsed. What bidwells don't cover, sir, are a number of other matters. For example, there is an issue of contamination, which I'm instructed is one of the core reasons why Columbia Threadneedle pulled out of its deal on the site. That should be something that the council can provide you with further information on, sir, because as I understand it, there is an open case with the Environment Agency regarding unresolved contamination issues on the site, which would undoubtedly need to be resolved prior to any residential development taking place on the site. So there's that issue. There's no reference to that issue in there and how that might be resolved. We don't have any programme. There's reference to a programme throughout this note, but we don't actually have a programme. And I think that's quite important, sir, because we're back to where we were 12, 18 months ago before Columbia Threadneedle got involved, possibly longer than 18 months ago, where we don't have house builders on board. And there is therefore a process that will need to be gone through in terms of marketing the site again, in terms of the commensurate beauty parade between house builders and their offers being put forward, the tendering process. There's then the issue of vacant possession of the site. I've mentioned the contamination. You, sir, have mentioned the UK oil and gas issue. All of those matters need to be factored into a programme before a house builder will proceed, or is chosen, in fact, to be able to proceed. And that's before we come on to another issue, sir, which is that, as you know, the site has outline consent for up to 1,800 dwellings. The council's trajectory has delivery of more than 1,800 dwellings on this site. 1,905, I think, if memory serves me correct, yes, from Appendix 1, 1,905. So that's 105 dwellings more than the site actually has planning permission for. And the obvious point there, sir, is there's going to need to be another planning application process. And we know from the evidence that's already before the examination that extending beyond the existing 1,800 dwellings will bring about other infrastructure constraints that need to be addressed, not least of which in relation to public transport. Again, there is nothing here in front of us to provide any comfort as to how that would be addressed. I said I'd try to be short. I think I've probably been longer than I anticipated, but just to bring that together, sir, it's simply unrealistic to expect delivery from this site within the 5-year period. The Annex 2 test is just not met. And so, as you know from my previous evidence, both written and orally, there are a number of very recent Section 78 decisions where your colleagues have reached exactly that view. Even in instances where I've suggested that there might be some delivery within the 5-year period. You do not have sufficient information, sufficient evidence before you to rely on that trajectory. The importance, of course, in terms of why do you need that information is because of the impact that it has on the capability of the development plan, parts 1 and part 2, to meet that minimum housing requirement by the end of the plan period. And so you'll see from my trajectory that has a dramatic impact in terms of the shortfall of just over 1,000 dwellings. But you'll also see from Mr. Berrett's trajectory, which is more favourable to the council's position, that actually only a marginal change in delivery, which is entirely reasonable, bearing in mind the uncertainties we're talking about here, even a marginal change in delivery will lead to a shortfall, and a significant shortfall. And that's a shortfall that needs to be addressed now within the scope of the Part 2 plan. I will stop at this point, sir, because I have some other more general points which I expect we can come back to later, and I can see other hands wishing to come in.
Yes, thank you, Mr. Neame. Ms. Ashton?
Thank you, sir. Just a couple of points following on from Mr. Neame. The first, in terms of house builder interest and what is said on page 4 about the fact that there have been discussions with house builders for some time and house builders remain highly interested to be part of the DPNS. There is no evidence before you of any house builder interest. No house builder has been here to help support the position, and a bit like Milford Golf Course, there has actually been no person attending these examination hearing sessions from the landowner themselves to help assist you with this. You have Bidwell's report, but you have nothing else. If a house builder were interested, and if a house builder were looking to forward an application in Q2 2023, you'd expect them to begin to be doing public consultation events now. You'd expect there to be a more detailed PPA in progress with a detailed programme of events, setting out how that reserve matters relates to the master plan and the infrastructure works and everything else. Bidwell suggests that you're going to get a reserve matters application basically concurrently with the approval of the master plan and the phasing plan. It's on the last page of their document. That to me sounds rather counterintuitive. Normally you would agree your master plan and your infrastructure works before you then put in your phase one reserve matters, because your phase one reserve matters would be predicated on that approved master plan. And as I say, the fact that there is an assertion that there is a house builder interest, but no house builder is actually flying the flag saying, yes, we're ready, we're coming over the hill to deliver, does lead one to actually question whether that is actually the case. The other point that Mr. Neame made, and I just want to reiterate, is the situation with how long the reserve matters is actually going to take. Milford Golf Course took 2 years, 3 months to get its reserve matters. It's for a significantly smaller site. And I'd suggest that a year to get a reserve matters on a scheme that for how many units we don't know. We don't know if it's going to be phased releases or what it's going to be, but nonetheless, my experience in Waverley is getting a reserve matters consent in a year is going it. That aside, just in terms of the trajectory, Mr. Neame points out that in Appendix 1 of item 34, the local authority referred to 1,905 units being delivered from Dunsfold during the plan period. But actually in Appendix 4, they refer to all 2,600. There is a clear difference between those two documents, both in terms of what they expect to be delivered from Dunsfold and what they actually expect the shortfall to be over the plan, or not the shortfall, sorry, the excess to be over the plan period. One suggests the excess is going to be in the region of 253, whereas Appendix 4 suggests it's going to be in the region of 692. Now, if you look at what's actually been consented on Dunsfold, or even if you look at what's in Appendix 34.1, if you accept that there is only 1,905 to be delivered in Dunsfold over the plan period, that takes Appendix 4 down by 695 units, which actually leaves it in a deficit, not a positive. That's if you accept that 1,905 will be delivered during the plan period. As you know, I don't, I know Mr. Neame doesn't, and I know various other people around the table don't. I said last July that there were discrepancies between Appendix 1 and what is now Appendix 4. There remain discrepancies between those documents and what is alleged to be being delivered from Dunsfold. I go back to the fact that I seriously cannot believe that A, reserve matters will get through in 12 months, and B, that they will actually be starting on site 12 months thereafter and delivering 120 units 12 months after that. That is an incredible delivery rate by anyone's measure, and it's not something that I've seen elsewhere, and I've dealt with a lot of large strategic sites in my time. I think I will leave it there. This all goes basically to the fragility of the housing land supply situation, sir, and the fact that all of us are suggesting that you need to look at a potential buffer and the allocation of additional sites. But again, like Mr. Neame, there are probably other things I want to say about the trajectory that I will come on to later, but that is Dunsfold related only. Thank you.
Thank you, Mr. Banner.
Thank you, sir. I adopt and agree with what you've heard from Mr. Neame and Miss Ashton. I won't repeat it, but I agree with it. I've got 6 further points. Firstly, I suggest it's very striking that no adjustment at all appears to be made to the trajectory in the light of the sale to Columbia Threadneedle falling through. very extreme position for the council to take, that it hasn't affected the deliverability of a single dwelling, hasn't caused a moment's delay. And so that's quite a useful sense check for you in terms of considering Mr. Neam's criticisms of the realism of the trajectory in light of the Bidwell's note. Second point, which is related also to the consequences of the sale falling through, is the ultimate landowner here, Trinity College, Cambridge, the richest of the Oxbridge colleges, is the paradigm of patient money. It doesn't need to make a quick buck. And that's really quite important in evaluating what's likely or probable or realistic to happen. Now, they don't need to rush ahead and find a lesser bidder. They could hold tight until they get the amount they want in the right economic climate. We're talking here about an asset that, given the nature of the consent and the location and the scale of the site, we're talking more than 100 million, probably considerably more. So sales of that nature take time. Trinity are clearly going to want to take time to get it right. It's entirely conceivable they might implement the permission and then sit tight. Thirdly, the note from Bidwell's postulates, as you've heard already, in fact you raised a question about it, that in the event that a buyer can't be found in the immediate future, they could start delivering the dwellings themselves. Now, so what I ask you to note in that respect is that the trajectory for Dunsfold in the council's trajectory, the trajectory is plainly assumes multiple house builders. I think the first year, I haven't got it on the screen because I've got you on my screen, but the first year I think is about 120 and it goes up into the 200s. And even if you slice off the affordable housing element, plainly in relation to the market housing element, it's assuming multiple starts. So the fallback put forward that the landowner, Trinity through DAL, would deliver housing, yes they might, but they plainly wouldn't do so at the pace assumed in the council's trajectory, and that's very important to bear in mind. So that was the third point. The fourth point, really on the same theme mentioned by Mr. Neame and Miss Ashton about the timescales, particularly from reserve matters to starts. This is the kind of site where it's plainly likely that reserve matters may very well themselves have pre-commencement conditions, as they invariably do. And a site this complex is very likely. And it doesn't seem to my mind to be any real regard had to that in the very accelerated timescale from reserve matters to commencements and occupations. That was the fourth point. The fifth point, this is yet another example of backloading. I made my point in relation to that, in relation to the Hazelmere sites. It's obvious when you look at the trajectory that even on the council's own case and its own assumptions, the deliverability of the LPP2 objectives in terms of delivery it is highly precarious, and that supports what Miss Ashton mentioned, supports the case for a buffer with additional sites that are oven ready as an insurance policy in the event these bold assumptions turn out not to be correct. So that's the fifth point. The sixth point, just a marker, sir, because we'll come back to this later, that these issues also bear upon custom and self-build, because broadly speaking, about half the council's self-claimed custom self-build supply comes from Dunsfold, according to its note. So clearly there are implications there, and that supports the rewording the policy that Mr. Mosier has put forward in his evidence, which we'll hear about later. Thank you.
Thank you, Mr. Banner. Mr. Burden.
Thank you, sir. Hopefully you can hear me this time. Like previous speakers, I'm not going to repeat everything I've said. I agree with everything that went before. One matter we haven't really dwelled on in this particular discussion is the SPD that was recently adopted in February this year, which you'll be well aware of, sir. And I know The councillor said this will help the delivery of the site. I would, based on my own experience, suggest that it's unlikely to do that. In fact, it's very much likely to do the opposite. I would like to draw your attention, sir, to section 4.5 of the SPD, which talks about delivery of the site moving forward. And obviously, as you'll be aware, sir, there's a requirement under policy SS7 and SS7A, I think, as well, of LPP1 for site-wide master plan to be prepared. And obviously, that was something that Columbia Threadneedle, I believe, were looking at and was likely to be revisited. I think most commentators in this session would hopefully agree that any new purchaser of this site would look to rework the existing planning permission. They'd have to rework the master plan, and they'd now have to show accordance with the SPD as well. And all of that in the timescales the council have suggested. And the council's note is curiously silent on the implications of this new SPD to that process. And just to be clear, sir, that is before the first reserve matters approval on this site. This is a complex site. It's an isolated site. It has a world of infrastructure challenges, as well as the other impediments that Mr. Neame in particular has drawn your attention to. As has been commented by many others, this site has been considered by many of your colleagues previously. Sometimes some inspectors have been rather generous in terms of suggesting some dwellings may come forward in the last of the 5-year period. But we're in a very different situation now with Columbia Threadneedle stepping away. There's nothing before you, sir, that gives any real confidence this is going to deliver. The Bidwell's note, frankly, is barely written. The work, the paper it's written on, it doesn't say anything of substance. And as Mr. Banner has just highlighted, universities work on long-term trajectories. They will not be in any rush to deliver this site. It's a very difficult site, and I don't think you can have any real certainty that anything will happen in this plan over this plan period. And just a final reminder, before we've only got 10 years of this plan period left. And I highlighted to you previously, sir, the trajectory in the back of LPP1 that had a massive peak last year, if I recall. It was based on Dunsfold delivering, I think, about 250 dwellings from a couple of years back. And of course, not a single house has appeared. Thank you.
Thank you, Mr. Burden. So if I could go back to the council, will you be responding on this one, Mr. Begler?
So no, I think we're still with Mr. Longley.
Yes, so, I'm not going to repeat the case that we made during the first hearings, because I think we were quite clear that Dunsfold is going to deliver. It's a nationally important scheme. If you're being invited to conclude that it's going to very significantly under-deliver, then in our view, that's a matter for the LPP1 review, because a different strategy that you're being invited to consider with a wide range of smaller sites dispersed more widely, that is a different spatial strategy, and that's one that ought to be at a strategic level assessed through LPP1. So I'm not going to go back over that ground. Just picking up a few points. A couple of people mentioned the PPA, the Plan and Performance Agreement. There is a new Plan and Performance Agreement that has been negotiated between the council and DAL, and that's awaiting signature, but that is provided lining up the resources needed to do the ongoing planning work as set out in this document. And I think the main purpose of us asking the Bidwells just to provide an update was not to go into finite detail, but just to reassure you that there's been no let-up of the pace of promotion of this site, and very substantial work programme as set out in their note is continuing. Mr. Banner's point about this scheme being backloaded, well, of course, major developments of this nature, all the garden communities across the country have experienced, well, the ones that I'm aware of have experienced delays just because of the sheer complexity and challenges of bringing forward major, well-planned developments of this nature. But that's not a reason to discount them and go for the quick option of a different strategy, as I previously said. I think, and there was a point made about ground contamination on page 3 of Bidwell's report. They do refer to the work that's ongoing, discharging condition 31 and condition 36 relating to contamination and soils. And I take it from the first paragraph on that page that those are, my reading of that is that those are currently undetermined applications that are with the council. So that work is ongoing, and it's wrong to suggest that's a new issue that will somehow put additional barriers in place. But clearly those are matters for careful consideration. So other than that, so you have our evidence. Clearly Bidwells are reinforcing the case that they're confident that the scheme will come forward to those timescales, and I think so you'll need to make your mind up on what we've been able to provide to date.
Thank you, Mr. Longley. So final point specifically on Dunsfold then, Mr. Banner.
I just wanted to come back on the characterisation a few moments ago of what I was saying as advocating a different option or a different strategy. That's patently not the case. Dunsfold will remain allocated. This is about timing, and this is about the role of LPP2 in picking up the slack to ensure that there is, in addition to Dunsfold in the longer term, which has been pushed back, immediate housing needs are met. So it's important that the case isn't mischaracterised. Thank you.
Thank you, Mr. Banner. Mr. Chapman.
Thank you, sir. Yes, it's just to reiterate what Mr. Banner has just said, actually, that we're not seeking that the council doesn't go forward with its strategy, but it's clear that not only the Dunsfold sites, but we've spoken about Hazelmere sites, the sites, the Milford Golf Course sites, that there are question marks about these sites coming forward in a timely manner. And the local authority, and I use the term they're giving us comfort, are not doing this. They are they're presenting documentation which is scant on detail, and they're asking us to put a great deal of trust in sites coming forward, which some very, very good points have been made today regarding their actually being able to deliver housing. Thank you.
Thank you, Mr. Neame.
Thank you, sir. So I think just 3 points. The first point, I agree totally with Mr. Banner, and just quantifying that in terms of numbers. So I mean, the point we're making here is exactly as Mr. Banner has conveyed, but actually the council itself has moved on from the Appendix C trajectory that it put forward at the local plan part 1 examination stage. As you know, sir, from looking at that Appendix C, at that point, Mr. Bohr was advised that this site would contribute 2,600 dwellings to the total supply by 2032. We're now in a position where the council are advising us here today that 1,905 dwellings will contribute towards the supply till 2032 on this site. So the council's position has changed. And so that's exactly the point that Mr. Bohr raised in his report when he considered the fragility of the supply, and more particularly the importance of the local plan part 2 and the significance that it plays in dealing with the council's housing requirement, particularly in circumstances as he envisaged might be the case at the time, where sites such as Dunsfold are delayed in terms of their delivery. That's exactly what's happened here, sir, and that's exactly what Mr. Bohr envisaged the local plan part 2 should be around to deal with, to pick up that slack. So that's the first point. Secondly, sir, on the PPA, Grateful to Mr. Longley for the update that there is a PPA addendum in the offing. He mentioned that it refers to the resources for the application work going forward. I'm grateful through you, Sarah, if we could perhaps just confirm that that's the same as the annual updates that have been undertaken, the last one on the council's website from June of last year, which effectively confirmed the same. What that doesn't do, and again, this is the point really, what it doesn't do is it doesn't confirm any kind of program, Sarah, it just confirms resourcing. And my point was the absence of a program. And then the third point, Sarah, is the contamination point, conditions 31 and 36. Yes, I was fully aware of the statement that Bidwells have made in relation to those conditions, and that work is clearly ongoing, and the applications to discharge those conditions, I don't believe, have been submitted. They certainly haven't been determined. Again, the council can confirm on that, but the contamination point's actually wider than simply complying with the terms of the permission, sir. My instructions are that there is an ongoing contamination issue. It is an open file with the Environment Agency concerning contaminants from the site leaching into watercourses. Now, so that's a problem for the site as it stands now, but of course it is a problem for any prospective house builder, because in a similar form to Columbia Threadneedle, no house builder will take on a site that has an unresolved contamination issue that could expose them to ultimately prosecution through separate means to the planning system. So that's just on the contamination point, so it's a wider point. I'll leave it there. Those were the 3 points. Thank you.
Thank you, Ms. Ashton.
Thank you, sir. Just a very brief point. Whilst I hear what Mr. Neame says about what's in the trajectory, and that referring to 1,905 for Dunsfold, I go back to the point that whilst Appendix 1 of document 34 says that, which is the trajectory, Appendix 4 of document 34 has 2,600 in it. It's not actually clear what the council themselves think is actually going to be delivered from Dunsfold. They seem to be hedging their bets. In one instance, they're saying it's only 1,905. In the other, they're saying it's 2,600. So irrelevant of what our position might be, the council's position itself is unclear.
Mr. Burden.
Thank you, sir. Going around the circles a bit on this, aren't we, if not careful, but in the absence of any real evidence from the council, it's really, really tricky for us all to help you with this. I think 2 very quick points for me, sir. Firstly, I believe it's a matter of fact that the site has not been put back on the market. Mr. Banner explained the economic realities of the colleges. Nothing's happened, sir. We had a very generic statement from the council a couple of months back, which only referred to the infrastructure moving forward. That's a similar message in the Bidwells document. And I won't repeat what I've just said. Just want to respond to the council's comments about the idea of effectively rewriting the council's local plan. That's not what I believe any of the participants are saying. I mentioned it in, I think it was the first set of sessions, sir. The local plan as drafted, with the use of the words minimum and other various phrases in terms of how it treats the various settlements from the settlement hierarchy, allow the council to make further allocations in a range of settlements across the settlement hierarchy. And if you recall, so I introduced the JR challenge the council made to my client's appeal that was allowed earlier this year. And the High Court judges were very clear on that there was no case to be argued. That to me reaffirms the fact, sir, that it is entirely within the gift of the council, if you so direct, to look at a number of different options across a range of settlements and stop the never-ending focus we seem to have in Waverley about the 4 main settlements and indeed Dunsfold, when they're simply not delivering on the housing numbers that are in LPP1. Thank you.
Thank you. And Mr. Moores.
Thank you, sir. Just to associate myself with what Mr. Banner, Mr. Neame and Mr. Burden have said, the council is fundamentally misrepresenting the case. Nobody is advocating a different strategy without Dunsfold. Casting my mind back to, I think, the first morning of the examination, I remember taking you to paragraph 57 of Inspector Bohr's examination report, where he quite clearly says that the risks to supply, for example, variations in the start date and delivery rate at Dunsfold, point strongly to the need for a positive approach and bringing forward the Part 2 plan. Our point is exactly that. The risks that Inspector Bohr envisaged have materialised. It's necessary for Part 2 plan to pick up the slack. Dunsfold will remain allocated. It just will not deliver in the plan period at the rates anticipated. That is the case the council has to meet, and I'm afraid nothing that Mr. Longley has said to you this afternoon answers that case. Thank you.
Thank you, Mr. Knowles. So any final points on that, please, Mr. Longley or Mr. Beglin, on any of those new points raised?
So I think it's going to be Mr. Longley on the detail, but you've just heard a series of objectors to the plan speak about the characterisation of their submissions and what it means for the spatial strategy in the plan. However those submissions are characterised, you will look and see the reality of the implications of what is being suggested. Now, the council's position is that Dunsfold will provide on the levels that the council has indicated for the reasons that have been set out previously, which are now supported by Appendix 6. But if you take a view that in fact the deficit is likely to be along the lines that Mr. Neame, for example, suggests, then that is not something that can consistently be addressed in a daughter document by rewriting the spatial distribution in the plan, and that would be in reality what would be happening. And so I'm not going to say any more about it because I'm conscious that we canvass these things in great detail on the earlier occasions, but bearing in mind that this point has been repeated by more than one contributor today, it's important to go back to that fundamental point that the authority was making at first instance, because it's not a matter of how the submissions are characterised, it's what they mean, what they will cause to happen to the relationship between Part 1 of the local plan and Part 2. And that's what we invite you to focus on when you're evaluating the submissions that have been made this afternoon at that high level of abstraction. Now, I'll just check if Mr. Longley has anything else he wants to add on the detail.
So perhaps just to help on the point that Ms. Ashton has made about discrepancy between Appendix 1 and Appendix 4. I think the issue is that there is an error on Appendix 4 in terms of if you look along the Dunsfold row, what this table is, Appendix 4 is basically what it says. It's the parish housing allocation. It's showing the difference between the allocation in the strategic plan policy ALH1 and what's been committed to date. That's basically showing what's left to allocate or identify. And in the second to last the third to last of the columns, the total commitments, column G, which should be the total of D plus F, and D being commitments, completions, permissions, windfalls, and F being LPP2 allocations. On that should be 18 for Dunsfold. It should be 1800 plus 0 equals 1800 rather than the 2600, which is obviously the in the second to last column, which is the local plan Part 1 minimum. So I think I would agree with what Ms. Ashton is saying. For the purposes of that table, the numbers for Dunsfold are actually minus 800 because the consent is only for 1800 compared to the 2600, albeit we are suggesting that there will be some additional on top of the existing permission that comes forward. So please don't confuse that table with the trajectory table, which I think is Appendix 1, which has the 1900 number, which is, as Mr. Beglin said, that's the council's case as to the potential of that site during the plan period. So apologies for any errors, and we can, or for that error, and we can make a revised version of that table available.
Yes, please, Longley, Mr. Longley, along the lines that that the correction is highlighted in anything that goes up on the examination website, please. Okay, so moving on a bit further. So we had a discussion in July about the contribution of C2 users to the overall supply, and the use of the methodology given in the housing delivery test rule book. So the council has set out its position on how the contribution of C2 users is treated in Appendix 5 of the Matter 2 statement. So, Mr. Neame, I just wondered whether you had a chance to absorb this, and have you got any comments, particularly on that narrative that the council has put forward?
Thank you. So yeah, I have had a chance to absorb it, is the short answer. I hadn't intended to make any specific points, save for an observation in relation to Hazelmere specifically, that as I understand it, and it's a question again through you, sir, really to the council, but as I understand it, there's actually an over provision of C2 bed spaces within that settlement, and therefore has the council taken that into account in squaring away the contribution that it envisages will come from effectively C2 uses releasing dwellings back into the supply? If there is already a surplus, presumably any new provision wouldn't therefore necessarily release further dwellings. So have they taken that into account in terms of the calculation? That's the only real observation I was going to make, sir, at this point, but happy to pick up on anything else if you want me to.
No, that's fine, Mr. Neame. I just called on you there because that was something that we had a discussion about, wasn't it, in July, and particularly in terms of provision of this further material. So, but yeah, that's a useful point. If we could go back to the council, particularly with that point and their views on it, please.
Yes, so you'll gather, if you can see us on camera, we're having a sort of frantic conflab to work out what the response is to that, and I think if you can give us a little while, and perhaps we'll come back to you after the next break, that would be very helpful.
Yeah, thank you, Mr. Longley. And in terms of whether there is anything different that needs to be done, or whether the approach that, or the clarification that Mr. Neame is looking for there it squares with what the housing delivery test rule book says, would be perhaps a useful position for you to take on that. If you could cross-reference it against that. But as you say, we'll come back to that after the break if you need to confer. I'll let you do that. So if we could, the other point I had was on the other sites in emerging neighbourhood development plan allocation. So is it the hearing statement describes in general what those terms encompass, but is there any sort of documentary data that backs that up, particularly where the sites have planning permission, and where the planning permissions of post data the 1st of April of this year? So is there anything further that could be added in terms of those. That's one point. And secondly, in terms of emerging neighbourhood plan allocations, this reference the LAA data that's supporting neighbourhood plan examinations. Is there any, could that data be added to the examination library as well, please?
So yes, I'm happy. I'm sure we can add the land variability assessment data for the neighbourhood plans onto the examination library. That's not a problem. I will just need to have a chat with colleagues about your first point that you made, and perhaps we can come back to you on that as well, if that's okay.
Yes, please. So are there any other reactions, particularly to those sites, the other sites and neighbourhood plan allocations from any other participants on the call? Okay, so in that, given that we've got to this point, and just I've said that the council can take some time to come back on the C2 points that we've discussed. I think if we adjourn now and come back at quarter past 3, please. Thank you.
So just before people leave, a point about timetabling, which I hope has reached you via the programme officer, and that's that we have the council chamber until 5:30, and it may be that we're making sufficient progress that will give us enough time. In the event that we need to go beyond 5:30, then we will need to relocate to another room, and it'll probably take us a little bit of time in order to get the technology up and running again. So I just raise that now in case it looks like it's beginning to become an issue.
Thank you, Mr. Beggan. My timetabling as well. I think I get chucked out of this building at 5, so it took me a bit longer to resume. So we'll do our best to keep that timetable, but we'll see how we're going when we get back from the adjournment.
Thank you, sir.
Okay, thank you. Okay, if we could resume, if I could go to Mr. Beglam for any reactions to the C2 matters and the other things I picked up just before the break.
So yes, if I can hand over first of all to Ms. Dove on those issues. Sorry, my mistake, Ms. Nash.
Thank you, sir. So we've had a discussion about those three questions you've raised. So the first one was in relation to C2 use and the comment that was made in relation to whether the council have thought about whether C2 is being over provided in certain areas of the borough. And we would refer you to paragraph 11 of the Housing Delivery Test Rulebook, which says about the ratio that should be applied to other communal accommodation based on the national average of adults in households. And it clearly states the methodology for doing that, and it doesn't make any reference to the need to consider whether over provision is being occurred in relation to C2 uses, and therefore the council contends that we are taking the correct approach with that, and inevitably C2 use provision in one area may be higher than in others and vice versa. And overall, Waverley do recognise that that type of accommodation is important for our borough, especially with an ageing population. So that's our response in relation to the C2 matter. The second question, I think, was in relation to the sites that fall under the other uses category. And I think most of the sites that we have put in there are sites that have subsequently received planning permission as a result of the 1st of April 2022 base date. And we're more than happy to provide evidence relating to which sites that applies to and any relevant decision notices. And it may be that now we're a few months on further from when we first produced that some more sites fall into that category as well, and we'll document that for you. And the third question was in relation to neighbourhood plan sites and those emerging through the neighbourhood planning process. So as far as we are aware, the neighbourhood plans that they apply to are the Elston neighbourhood plan, the Dunsfold neighbourhood plan, and the Cranley neighbourhood plan. And we shall create a document that lists the sites that make up those numbers as shown in the documents that we've already provided, and clearly kind of provide the evidence that defines those sites and what numbers we're attributing to those sites.
Thanks, Ms. Nash. And if that's separately evidence on the basis of an LAA that's produced specifically for the neighbourhood plan, if those could be provided, or certainly links through to those would be useful.
And I think for different neighbourhood plans, they've taken different approaches to how they've produced a LAR document, or whether it's a housing allocations type topic paper, but we'll find the most appropriate documents for each and reference those accordingly.
Thank you. So I've got no further specific questions on the housing trajectory or related information. But are there any other points that others wish to raise before we close this session? Mr. Neame.
Thank you, sir. And again, I'll endeavour not to repeat myself, but I think I just want to spend 5 minutes, if I may, on a point which we have discussed before, but doesn't appear to have been answered in the council statement. So we have updated housing trajectory evidence in the appendix 1 to the council statement, sir, and there is no reference whatsoever within the council's statement itself to why we have an updated trajectory that uses the Liverpool method to calculate the rolling 5-year supply. No evidence at all. Now, we've been through this point before, and no doubt Mr. Beglam will come back on this point as he did before, but Mr. Beglin's protest in relation to the relevance of Liverpool does not amount to evidence as to why a departure from the council's accepted position in the context of the local plan part 1, the recommendation as accepted by your colleague in relation to that part 1 examination, together with clearly established national policy, why a departure should even be considered. Why is it even relevant? And so I flag it because the council have obviously put it into this document for some reason, but they haven't specified why. It can't be to demonstrate to you that they have a 5-year supply, because of course the council suggests to you that they have a 5.1-year supply applying Sedgefield. Even more reason for why Liverpool is completely irrelevant. And I think the final point, Sarah, is we've heard a lot more today from the council about the general approach that it envisages taking in relation to the local plan part 1, primarily in relation to answers to questions that you've posed, which would clearly, to me, indicate quite rightly that when the council takes a decision on what it should do with the local plan part 1, in line with paragraph 33 of the framework, that it will need to update its strategic policies. Now, assuming that the council takes that correct approach, then of course the standard method for calculating housing requirement will kick in, and the debate over Liverpool Sedgefield is irrelevant. So I just flag it, sir, because the council have put this material in presumably for a reason that's unspecified. To my mind, there is absolutely no basis for it. And I would ask through you, sir, for clarity that there really is no merit to it, and it certainly shouldn't form part of your consideration. I would ask for the clarity from the council to that effect, please.
Thank you, Mr. Neame. Mr. Chapman.
Thank you, sir. I won't labour the point, but there's something that I raised in the previous sessions, in that with regard to the neighbourhood plans, experience tells that they aren't going to be overly cooperative with regard to producing another, or looking to allocate another sites coming forward. And just as an example, we have a situation with Cranley, whereby the neighbourhood plan has been some 10 years in the coming. It's likely to be going out again for reconsultation, and it's very much on the basis that a number of sites that have been granted plan permission or are in the process of being determined, either application or appeal, waiting for a decision on those and looking to allocate those sites as being sites that have as their allocated sites. Also, again, I hate to say it, but it is very much the case in the numbers that are set out in the local plan. The parishes will look at those as being the amount of housing they should supply, and they'll be reluctant to look to provide any more than those cited. Thank you.
Thank you. Okay, if I can go back to the council just for some brief responses to those points before we wrap up on this particular matter.
So just on the Liverpool versus Sedgefield, we are now at risk of going back over matters that we traversed on the last occasion, but it's precisely because of those arguments that we put forward on the last occasion that Liverpool remains here as a sensitivity test, and to demonstrate an alternative approach that we say it is open to you to take in light of the changed circumstances since LPP Part 1 was adopted. And we went through the detail in relation to that on previous occasions. And of course, part of Mr. Neame's answer to that is to say, well, this can't be of any interest in terms of demonstrating 5-year housing land supply, because the council says it has 5.1 years. And of course the council does, but others do not agree, and they seek to say that we have far less. And in those circumstances, it's reasonable and appropriate to look at alternative measures. And the one that we invited your attention to was Liverpool. And we did it for specific reasons on the last occasion related to what had changed in particular in relation to Dunsfold, but it applies to other strategic sites as well. The golf course is the other obvious example. And those two things, Dunsfold in particular being central to the overall spatial strategy, as I indicated to you on the previous occasion, that raises a question, well, how does one react to that set of circumstances where Inspector Ball had perfectly reasonably assumed certain rates of delivery for Dunsfold at the time, which in the event have not transpired? It is the appropriate, as it were, policy response to say, well, actually, what we should do is accept the implications of what the objectors are suggesting, which is a manifest departure from the overall spatial strategy and its central component in Dunsfold? Or should we consider whether or not there is merit in looking at the Liverpool approach when the circumstances, whilst they can never be the same one to another, the circumstances bear comparison with what has happened elsewhere, in particular in relation to Mid Sussex. And that was the example I gave last time around. Mr. Neame gave his reasons for disagreeing with it. So all of those matters have already been canvassed. And I simply say that to remind you of the flavour of the discussion that we had on the last occasion. But that's why the material is contained within our analysis. And of course, we're putting forward the position of the council, and the evidence is there. The evidence is there in relation to how Dunsfold has performed compared to, for example, how Inspector Ball anticipated it would perform. So the material is there, and then the evaluation is, well, what is the most appropriate policy response to that? And we gave the Liverpool measure as being one way to test the appropriateness of the situation, and indeed to provide a policy response that serves to maintain the integrity of the overall policies in LPP1, and at the same time recognising all the circumstances that we set out on the last occasion, which I don't rehearse, but which include the review, which will deal with those with those strategic issues. And again, to refer forward to what the review will do and whether or not the approach that will be taken under the standard method, again, that is all for consideration at the appropriate time when the review comes forward. So it doesn't necessarily assist your analysis to say what the implications of the standard method being applied will be, because we don't know yet. At that stage, there will need to be a review that deals not just with the demand side, but clearly also with the supply side, and that's what will happen. I'll just look down the road, see if anyone else wants to add in relation to the points that were made just before the break. So no, I think that's it from us on those points. Sorry, Mr. Stroke.
So yeah, I just wanted to come back on Mr. Chapman's point. I hope I've captured him correctly, because it was rather muffled from here. But I think what he was saying about the commitments from the parish councils with regard to their neighbourhood plans, we've obviously had a number of parish councils which have undertaken that responsibility, and in terms of site allocations have obviously met the numbers that are required in local plan part 1. And indeed, as you know, sir, that one of the basic conditions test is that they need to meet that number. In terms of the emerging plans, they're all committed to dealing with them as soon as possible. They're obviously moving forward to them, and as I say, we will explain that in our note when we set out our response to them. But in at least one of the cases, I think it's Elster, they're actually putting forward more houses than actually is the requirement there that they're putting forward as an allocation.
Thank you, Mr. Banner.
I just wanted to quickly come back, sir, on what Mr. Beglan said in response to Mr. Neame. His characterisation of the rationale for the Liverpool approach is a paradigm example of moving the goalposts. What the council, on Mr. Beglan's own characterisation, has done is there's been a delay in delivery of important sites, and the council's response to that is to massage the requirement figure, the requirement timeline, so as to avoid the consequences of the delay in delivery, which is to plan for making up that shortfall of immediate housing needs. On the approach Mr. Beglan has outlined, the immediate needs, which are now and in the early period of the LPP2, will simply not be met. And the Liverpool method masks that it conceals it. And that's fundamental to really everything you've heard from a very vast number of protagonists at this examination, that need for slack to be picked up. Thank you.
Final points, Mr. Beglan.
So no, I'm not proposing to add anything further on that point unless there's a specific question you had. The council's view is that we did get an opportunity to rehearse those points fairly fully on the last occasion, and we're grateful for that.
Okay, thank you. So that, as I say, I've got no other questions on matter 2. So that concludes the discussion of that matter. If we can now move on to matter 3, which is a specific question I posed about the custom and self-build housing. So if we could open this session with the usual opening question to the council on the justification for the threshold contained in policy DM36 and the percentage requirement that's set out there. And it will also be helpful to me if you could outline proposed modifications to the policy that you have suggested since our earlier discussion on this topic.
Thank you, sir. Yeah, I think at the initial hearings we explained the approach and the 5% on sites of 20 or more dwellings. Obviously, mathematically, that gives you at least one plot, and we, I think, provided at least one example of where that approach had been taken in another authority where it was largely rural and reliant on a number of small sites. So that's the reason the policy is as submitted. We've provided an indication of the number of plots that would come forward if all of the sites over 20 dwellings were to make a contribution. However, as we discussed last time, we recognise that it won't be feasible for some sites, for example, where they involve apartments over commercial space, it wouldn't be feasible for those to provide customer self-build plots. So we've proposed adding a word into policy DM36, or adding 2 words rather, to relate to the feasible or viable point. And this was the discussion with the HBF. And you'll see, so that we've also proposed a new paragraph 6.12 to put a bit more flesh around that. We've also suggested a further main modification, again reflecting the discussion last time round, and on reflection it did seem incongruous that the supporting text for each of the site allocations picked out custom self-build in particular in each occasion. It didn't mention the affordable housing requirements, which for Waverley are actually a bigger priority. So we're suggesting simply striking out those words in relation to each of the site allocations and relying instead on the overarching policy, which is to be applied on any sites over 20. So that's the reason for that. The other part of our notes, so as requested, we've, as I say, we've looked at the supply side from sites. You heard earlier around Dunsfold, the initial consent secures 25, at least 25 plots. Obviously, that relates to the first 1,800, and what comes forward beyond 1,800 would be subject to the 5% requirement. So there's another element potentially to factor in there. And the only other main aspect that we haven't mentioned, but on reflection, it is an opportunity, is that the rural exceptions policy in LPP1 could of course be used if there are affordable schemes for customer self-build that come forward. So it's very difficult to quantify that, but that is a mechanism that's reflected in some of the local plans, the Wellingborough Part 2 local plan being one such example.
So the analysis looks at allocations that are in the Part 2 plan and what Dunsfold is anticipated to deliver in terms of self-build and custom. But have you got a view on some of the other sites that are in the trajectory and what they may yield over a plan period, Mr. Longley?
Helps if I turn that on. In terms of the local plan Part 1 allocations, that there wasn't a policy on customer self-build in that plan. It came a little too early for that, and the consents that are being granted on all of the sites, with the exception of Dunsfold, haven't included customer self-build. That's not to say that it might not come back in, because there are successful examples of customer self-build around the country, and it's possible that there may be a commercial reason for developers to bring it forward, but there is no requirement in the consents for those sites for customer self-build. And so the other aspect is that some of the neighbourhood plan allocations, I understand, do have a requirement for customer self-build. And so, yeah, I'm reminded that in our statement on page 2, we refer to a site in Chiddingfold neighbourhood plan for 3 customer self-build building plots.
Thank you, Mr. Longley. So if I can go over to Mr. Mogan now. So in terms of your statement on this matter, you consider that the council's assessment of need for this type of accommodation might be an underestimate. So could you outline that point, please?
Certainly, sir. Yes. Sorry, just to raise a matter of order, I don't appear to have the raised hand function, so I may have to just chip in at times, I'm afraid, rather than be able to raise my hand on Zoom. There's 4 main, I think, points that I want to draw on. The first is register numbers. The second is the suppression of the register. The third is secondary data sources, and then the fourth is the council's strategy for meeting demand. So if we look first at the register numbers, we've got 4 different sets of data. We've got data provided through Freedom of Information, the council's data returns to central government, the figures that the council reports in its AMR, and then we've got the figures the council now puts in its matter statement 9. And I set these out at page 4 of my statement of figure 2.1. I don't propose that we go to those, but you'll have seen that they differ wildly between which of the source you rely upon. But in any event, the council accepts that there remains an unmet demand within Waverley. Now, what the council's done is they've retrospectively removed people from their register, and then they've sought to measure this amended register against the statutory duty. So the 2015 Self and Custom Build Act as amended places a legal duty on a council to meet registered demand within 3 years from the end of a base period. And what the Act says is that demand is evidenced by the numbers added during period to a register, and that an authority has to grant enough permissions to meet demand arising in each base period. Or in other words, it's not to be measured against a retrospectively revised register. So when the statutory duty is correctly applied, then the council hasn't met its duty for base periods 1, 2, and 3, and it has a pending shortfall for base period 4. So I think one of the questions we have to ask is why has the council sought to remove people and then measure against lower numbers? Now, possibly this is because the strategy that the council proposes only has 52 plots across all allocations. And that's despite overall allocations across the two plans exceeding 5,000 dwellings. I'll come back to that point, but that sort of neatly takes us into the suppression of the register. So what the council's done here is they've imposed an initial registration fee and then an annual retainer fee on top of that. They've also introduced a local connection test. And the effect of the local connection test is that the statutory duty then only applies to part 1 of the register. The local connection splits the register into 2 parts, part 1 being people with a local connection, part 2 being everyone else. But part 2 is still a material consideration. Now, the council introduced a local connection in 2018, March 2018, so that was part way through base period 3 and then retrospectively applied it. Now, the relevance of this is that the National Customer Self-Build Association, NACSPA, identify these sort of approaches as being used purely to quash register demand. And that becomes evident when we look at the register numbers based on the council's data returns to central government prior to the introduction of the tests and the fees. So base periods 1 to 2, we had an average of 77 people per annum joining. Then, once the fees and local connection tests were applied, across base periods 3 to 5, we have an average of 14 people per annum joining. So that's an 81% decrease. The PPG, where it talks about local connection tests, says that you should only apply these tests where there's a strong justification for doing so. There's clear information on the rationale for them. It recommends they're consulted upon and that they're reviewed periodically. And none of this appears to have happened here. We don't see any evidence of the register actually being unmanageable before the tests. So I have to question why those were introduced. So then when you take the next step onto secondary data, the register has been suppressed, so other sources are highly relevant. And the PPG says that for a robust assessment of self and custom build demand, they should review the register data and supplement it with secondary data sources. So there's 3 main secondary data sources that I just wanted to draw upon. The first is BuildStore. So BuildStore hold the largest database of prospective self and custom builders in the country. There's 2 parts to the BuildStore data. The first is their custom build register. So this is people who are seeking an opportunity for a customizable home. And the second is plot search, and this is people who are looking for a service plot of land to build or commission their own home. But the data that BuildStore provided for Waverley shows for the custom build register, there's 352 people seeking a customizable home in Waverley. The 2015 SHMA used some BuildStore data, and what we see is the numbers on the custom build register for BuildStore now are up 410% since the 2015 SHMA. Then when we look at the plot search numbers, they're up 268% since the 2015 SHMA. There's 1,001 plot search subscribers seeking a service plot in this authority area. And the second secondary data source is Ipsos Mori polling undertaken for the National Customer Self-Build Association. That polling has consistently shown between 2016 and 2020 that around 1 in 50 of the adult population want to self-build. So if you then apply that ratio to the adult population in Waverley, then that estimates that as many as 977 people would be looking to self or custom build in this authority area. The third one then is AMA market research. So this research has been undertaken and it looks at self-building as part of overall house building in the UK. And that market research found that self and custom build constitutes between 7 and 10% of house building. So if you were to apply, again, that ratio to the standard method for Waverley, then that results in an overall need for between 1,040 and 1,480 plots across the plan period. But the important thing here, of course, is that the secondary data sources are not suppressed, and they are showing that demand in this area actually is very strong. So we then go on to the strategy that the council has to meet this demand. Now, effectively, there's two parts to policy DM36. The first being the 5% requirement on sites of 20 or more. And then the second part being support for self and custom build on smaller sites. So what the council appear to be suggesting now is a watering down of that policy to some degree through MM81 to enable opt-outs of the 5% requirement or a lower percentage offer. So on a best case scenario, the council is expecting 52 plots from allocations. 25 of those are from Dunsfold, and those plots are unlikely to come forward within the next 5 to 10 years. So you're looking at perhaps half of the supply not coming forward for a decade. And then the remainder of that may not now come forward at 5% or at all if the council introduced the main modification allowing for a step out from those percentage requirements. So in either scenario, the strategy isn't going to come close to meeting demand. And our experience has been across a number of these sites, applications and appeals that percentage offers on larger sites do tend to come forward in the later development phases. And there's reasons for that, and primarily because the service roads and servicing need to be in place for those plots, and the developer needs the housing sales to fund the progress of that. And what they also like to do is to have effectively their construction force off the site before the self-builders constructors come on for a construction management reasons. So what we know is that standalone smaller self-build schemes come forward far quicker to meet demand than the percentage plot requirements do on larger sites. So in my view, the resolution to this is that the second part of DM36 needs strengthening in order for the plan to be sound and to meet the needs of different groups, including self-builders, as per paragraph 62 of the MPPF. So to do that, it needs to have a far stronger degree of support for smaller sites, i.e. those under the 20 threshold in part 1 of the policy, and to allow for smaller schemes to come forward outside of settlement limits, where it's demonstrated that demand is not being met. And that ties with one of the recommendations of the Bacon Review into scaling up self and custom build, which was commissioned by the previous Prime Minister. So those are my main points on the council strategy and the register numbers.
Thank you, Mr. Morgan. So if I can go back to the council then for reflections, firstly on that view that's been expressed about whether the needs analysis is accurate in the light of those considerations that Mr. Moga has referred us to. And secondly, in terms of Mr. Moga's proposed main modification to policy DM36 in terms of those smaller sites, which is set out just below paragraph 3.5 of his hearing statement.
So yes, if I start off on this one, and then I think some other members of the team are going to want to contribute. But in terms of where this hearing statement is going, so you'll recall the conversation that we had last time in relation to custom and self-build, and it was relating to whether or not there needed to be changes to the policy precisely so as to allow certain sites to come out of that obligation on the basis that it wouldn't be feasible for there to be such provision. So that's the nature of the discussion that was taking place at that stage with the assistance of the HBF amongst others. And it's on that basis that we put forward the proposed main modifications to you. Now, as we understood these sessions, they are to, as it were, address any further representations that people want to make based on those changes that were being put forward by the council at that stage. Instead, what we now have, but perhaps in contrast to your suggestion that any further evidence should be in short hearing statements, we have a 17-page hearing statement that attempts to address what we suggest are new issues in relation to this topic and this policy. And Mr. Longley may want to say more about this, but we've checked back through the records to try and see if there was an earlier articulation of any of the detail of the points that are now being made. And we weren't able to find that, having looked through. So there is a very active question for you as to whether or not at this stage in the process, bearing in mind where we are, whether or not these are matters that we should be entertaining in the first instance. But if we are going to move forward and consider them, then so you will presumably want to do that against the backdrop of having looked at or reminded yourself about the primary legislation and the secondary legislation, because it does bear on these issues. So, for example, within the primary legislation contained within the Self-Build and Custom House Building Act of 2015, the first obligation on local planning authorities in section 2.1 is to have regard to each register when carrying out their functions, which include their planning functions, their housing functions, and certain other functions as well, such as disposal of land. And planning comes in section 2, subsection 4, letter A. And then it's section 2A that was inserted that contains the duty to give suitable development permission to meet the demand arising in each base period. So it's a requirement, first of all, in relation to development permission rather than implementation or provision. And there's a clear focus as one goes through the statutory scheme, in fact, to the development management side rather than necessarily local planning. The way that demand is to be calculated is set out within the statute itself. And then section 3 contains further provision requiring the local planning authority to have regard to any guidance issued by the Secretary of State when exercising these functions. Within the primary legislation, just to remind you where it is, sir, it's paragraph 6 of Schedule 1 that allows regulations to be made for provision of fees, and that was done. There are a number of pieces of secondary legislation, but perhaps the most important are the regulations that were made in 2016 under statutory instrument number 2016-950, because those regulations deal with eligibility for entry onto the register. First of all, that's regulation 4, and then regulation 4.3c provides that someone is only eligible for entry if they meet the local eligibility conditions, and the regulations make provision for local eligibility conditions to be put in place. Regulation 5.2 gives a broad power to local authorities to set a local connection test for eligibility, and that's what this authority has chosen to do. There are then some further regulations dealing with the form that applications for entry have to take and the way that those applications are to be determined. And then importantly, in regulation 10.2 of the secondary legislation, there's provision for removal of the entry from the register. And the essential provision is that a relevant authority may remove someone who, I quote, is no longer eligible for entry in the register. So it's individuals who may have been entered, but who in the judgment of the authority for a valid reason are no longer eligible for entry. And then regulation 10.3 protects anyone who's removed by that means, because they have to be given a notification and they have to be told the reasons for their removal. So that's the protection they have. when that happens to them as an individual. The time for compliance and fees regulations are separate. That's Statutory Instrument 2016-1027. And it's Regulation 2 that provides the requirement to comply with the demand for any given base period within 3 years, beginning immediately after the end of the base period. So that's where that comes from. And Regulation 3 provides a power to charge fees, firstly for entry and to remain on the register. So whilst there's been reference to steps that the local authority may choose to take that may have the effect of suppressing the number of people who put themselves on the register, those are steps that the local authority is perfectly entitled to take in accordance with the regulatory scheme that applies here. Just in terms of the other sources of authority that are available, the NPPF, we know paragraph 62 contains the reference that deals with provision of custom and self-build along with housing for older people, affordable housing and so on, and it's treated in the same vein as those groups within paragraph 62, the implication being that there's no requirement within the local planning process on the planning side to make full provision in relation to this category of need. And what's required is assessment and reflection in planning policies. That's paragraph 62 and footnote 28, which deals more specifically with the requirements of the 2015 Act. And then within the PPG, said for your reference, it's ID 57025. And that deals also the PPG with local eligibility tests. That reference is 57020. And as has been pointed out, one of the bases upon which an eligibility test can be introduced is where the authority suffers with limited land availability. And the material that we've heard through this examination is self-explanatory in that respect. And the guidance also provides that for designing a local connection test, authorities may wish to consider criteria based on residency, having a family member residing in the local area and or having an employment connection to the local area, all things that are familiar to those who deal with local connection policies that are in the housing sphere. And that is what the authority has done here. They've used essentially the same eligibility approach. So it's against that backdrop that the observations that are now made are being made. And we say in those circumstances that in fact the authority was entitled under the regulatory scheme to have eligibility conditions. It was entitled to apply those to people who are already on the register, and the consequence may be their removal from the register. And so to that extent, we certainly don't accept the arithmetic that's now being put forward in support of the change that is being said to you is necessary in order to render the plan sound. So that's dealing with matters at that relatively high level of abstraction. And also simply to note perhaps that what's being suggested in terms of there being an ability to develop outside of the settlement boundaries as an exceptions policy would of course run a coach and horses through the overall approach that's taken via both local plan part 1 and carried on by local plan part 2. So those are my observations, and it may be that either Mr. Longley or Ms. Nash want to add more on the detail.
And only a couple of responses because I think Mr. Beglin has covered it. But yeah, I was surprised to see these detailed response coming in at this stage because as has been said, there was no previous representation made at Regulation 19 or any other time in relation to these matters from Monk Hill. So it obviously has created some difficulty for us in responding in the time given to a brand new set of issues, which obviously run counter to the discussion at July's session on this. Apart from that, that moan, I suppose the only other point I'd make is in relation to there's been talk about suppressing demand and the council not not taking the right approach to doing that. I see it more as sifting out the serious people from the register, those that have a genuine intention to take up a plot and who can afford to take up a plot and have a local connection, as opposed to people who have a general aspiration who may appear on registers across the country and obviously fall away very quickly when a £25 charge is introduced. Considering the costs of actually doing a self-build, that should hardly be a disincentive. So those are the main. So I think just to finish on that point, it is a very sensible and responsible thing for the council to do that, given the responsibilities that the register brings with it, and the mechanisms to do that, as Mr. Beglin has said, are set out for the council to use should it choose to do so. And then the final point in terms of the policy, the proposed policy, I just reiterate the fact that the loose wording of that would really open up and undermine the restraint policies around our settlements, purely on the basis that somebody is seeking to build their own home, and that is clearly not the intention or the strategy that exists in Waverley.
So, Mr. Longley, if I could just clarify, the annual fee to be included on the register, that's £25 per entry, is it?
So I think it was £25 when it was first introduced. However, it has increased with inflation since that date. So we could clarify the exact charge that it is at the moment. And just in addition to the points made previously, I'd just add that the other thing that we are keen to emphasise is that self-build and custom-build plots do come forward naturally, as well as through the policies that are in place. So we charge still here at Waverley, and self-build exemption is claimed by numerous individuals each year at Waverley, hence exemplifying that these opportunities do come forward naturally, as well as through policy-driven approaches.
Mr. Banner.
Thank you, sir. I'm going to start, then pass over to the handless Mr. Mosier. I can raise my hand. So firstly, it's a little unclear to me whether the council is simply moaning about our evidence in this respect or formally objecting to it. I'm taking it as a moan because it's responded to it. If it is a formal objection, we should have been told beforehand, because there are references in our written material to custom and self-build housing. I can give them to you if you need them, but I'll say it's a little unfortunate to be ambushed with an objection if it is an objection, but I say I'll presume it's not. Mr. Beglin, early on in his comments, suggested really this wasn't a matter for plan making but for decision taking, but he went on to draw your attention to paragraph 62 of the framework, which obviously is directed at planning policies in terms, and he rather skimmed over what it says because it requires the need to be assessed and then reflected. Maybe not an absolute provision in the same way of 5-year housing land supply, but there clearly needs to be an assessment and then some kind of dealing with the assessed need. And Mr. Mosier's key point is the assessment hasn't been done in the way that it should have been done. So something, therefore, and if that's right, it hasn't properly been assessed for the purposes of framework paragraph 62, and that bears upon soundness. So there is a key point there. Plainly, there has to be some kind of reflection, and that's where on the supply side, the Dunsfold type issues come to bear. Next point is it's not simply about sort of 5% custom and self-build silos in certain developments, because there are some custom and self-build schemes that are 100% custom and self-build, and that is a well-established way of delivering this kind of housing. And the policy refinements that have been put forward in the Tetlow King material would allow for that form of development to come forward to meet identified needs. It's not the case it would be a carte blanche to develop anywhere in the council's area, because of course there'll be other policies that would be in play too, such as policies in relation to landscape and greenbelt and so on. And lastly, before I hand over, the comments made about the local connection test and why in some circumstances local connection test might be a good idea. What they overlook is that there's a particular prescribed way you go about a local connection test, and the council hasn't gone about that way here. So simply saying, well, there could be quite a good rationale for it, doesn't meet the Tetlow King observations. With that, I'll pass over to Mr. Mosier in case he wants to make any more substantive comments.
Thank you. Yes, so you were you were directed to paragraph 5720 of the Self and Custom Build section of the PPG. If I could just draw your attention to the paragraph that precedes that, 57019, and that talks about local eligibility tests and says that an authority would apply one or both of the tests only where they have a strong justification for doing so. And we still don't see that from the council. We haven't seen that in evidence. We haven't seen any explanation from the council as to what that strong justification is. And it appears to be having been undertaken to suppress numbers. In terms of an exception type site approach, I mean, I think it's unfair to say it's carte blanche. I mean, what we're suggesting is that such sites only come forward where it's demonstrated that demand is not being met. So there's a threshold to the application of that amendment proposed to the policy. The council also said that when they applied the fees and register numbers dropped, they were of the view that that meant that those people were the people who were realistic about self and custom building. But I think what we have to bear in mind with that is what you actually get for being on self and custom build register, because it doesn't guarantee you permission. It doesn't give you assistance with necessarily with finding a plot or with finding an appropriate self and custom build mortgage, or assistance with finding architects and builders and so on. So if you're asked to pay, I can help you with the fees. So it's £31 to enter, and then it's £15.50 per annum after that. If you're asked effectively to pay £46.50 every year for nothing, well, of course, you would choose not to do that. By comparison, the BuildStore numbers, so BuildStore are the largest broker of self and custom build mortgages in the country. They have their own specialist enabling arm, Custom Build Homes, who can assist with actual delivery of the self and custom build units. So I would suggest actually that the numbers on their register are more reflective of people who are serious about this, because you get much more for entry on the custom build register than you do on the council's self build register. The point was also made to you about SIL, and that the council are saying that they had a number of people who are achieving the SIL self-build exemption. Now, the difficulty with relying upon SIL self-build exemptions is that you can qualify for the SIL self-build exemption yet not meet the legislative definition of what constitutes self and custom build. And what I mean by that is you can have a scenario where somebody obtains a planning permission on their land. They then sell that with permission to somebody else. That purchaser then builds out that permission to live in. They qualify for the SIL self-build exemption, but they've had no input whatsoever into design and layout. And that is what the primary legislation requires, and the PPG. So it's not robust to simply say, well, we've got a number of SIL exemption sites without further interrogating that data to see, well, actually, how many of those are people who actually were the applicants who have then gone on to live in it because they've had primary input, design and layout. And just one final point, it's taking a bit of a step back. So there was comments at the start about the rural exception site policy for affordable housing and self and custom build as a potential route for supply. Now, our experience has been that registered providers, they don't like this form of housing, and there's very specific reasons for that. And that's because of the requirement to have primary input into design and layout, it can make it problematic for them for future relets of properties where somebody's had that input. So it's extraordinarily rare actually for self and custom build to come forward through an RP led affordable housing development. It's more common on a discount market sell type development, but that isn't what we're seeing RPs delivering.
Thank you. So any final responses to those points, Mr. Beglam?
So yes, briefly, it appears to be common ground between all the parties that referring to the NPPF, what's being dealt with here is not an absolute requirement. It falls within the same category as affordable housing and so on, at least for the purposes of local planning. Secondly, it's always open to an individual applicant if they think that they've got a good enough justification because they're providing self-build or custom housing in circumstances where the need vastly outstrips the available supply, to say, well, that's a material planning consideration and it ought to be allowed outside the settlement boundary for those reasons. That's not a justification for saying that the plan as proposed is necessarily unsound. In terms of the application of the local connection test, the position is that we have adopted a local connection test. We did that in accordance with the regulations. No one has demonstrated that there was any error by us in adopting that test in accordance with the regulations, and so it falls to be applied. So if it helps you, we can supply the committee report which led to that policy being adopted. But the shorter point is that it was adopted. It was adopted some time ago. It hasn't been successfully challenged, so it remains in force. We're entitled to apply it. That's what we've done. And we don't accept, for what it's worth at this stage in time, that we didn't have a justification for applying it. And insofar as the suggestion is, what do you get for registration? The sums that are being required, first of all, again, we are perfectly entitled to charge under the statutory scheme. And that's what we've done. And on any view, I would invite you to consider that these sums are indeed nominal sums compared to the idea that individuals who are on Part 1 of the register will be wanting to construct properties of self-build or custom nature. So in those circumstances, we say there's no justification for making a change to the plan along the lines that have been highlighted to you this afternoon. And again, I'll just check down the row, because it may be that colleagues have observations on some of the other ways of measuring the claimed level of need or other matters. I'll just check.
So just a couple of points on Mr. Banner's point, whether this is a moan or an objection. I think it falls in the moan category, because we're entirely in your hands as to how you wish to deal with this. But I think it would be helpful if Mr. Banner could direct us to the representations that covered this aspect of custom and self-build, because I may have missed them, but I think this is the first time this has arisen. The cost of entering the register, just for to be bang up to date, it's gone all the way up to £32 to enter the register and £16 to remain on it. And final point around the wording of the policy, and it's apparently not a carte blanche to overcome restraint policies, because it would only apply when need is not met. Well, obviously the evidence that's been put to you today is that need is not being met, and it's not being met by a huge margin according to the representation. So it would in effect be a policy that's permanently on mode.
Final points, Mr. Moga, please.
Thank you, sir. So we've heard now from the council about a committee report for local connection. We still haven't heard a justification from them as to why it was introduced. They simply seem to be saying we're allowed to, so we did it. They haven't given a justification for why they've done it. And I think we stand by the point that it appears to be done to reduce register numbers. The same goes for the fee. Yes, they're allowed to introduce it, but again, we haven't heard a justification for it. And it's okay for the council to say it's a nominal sum of £48 to join, and then you're £16 now per annum. But if you aren't getting anything for that, then why on earth would you continue to pay that?
Okay, thank you. Yeah, that's well, position on that's well understood. Just to go back to the council, in terms of that committee report, yes, if that could be uploaded to the examination website. If on the rest of this material, it's something that I'll reflect on as the examination progresses and in post hearings correspondence as necessary. But I don't have any further questions on this topic at this point. Anything final to add, Mr. Beglam?
So no, but thank you. But we'll make sure that report's uploaded.
Thank you. So if we could now move on to matter 1, which was the just the outstanding question on the habitats regulation assessment. So there's a consolidated habitats regulation assessment that's been prepared and made available on the examination website. So on this, I'm happy to take the council statement as read, but are there any specifics that you would like to pick up or draw to my attention on this point, Mr. Beglan? Or I see Mr. Riley has joined us as well.
So I don't know if Dr. Riley does, but if you're content with what we've set out within the hearing statement, I think we're probably happy to leave it there. Mr. Riley.
Yes, I'm merely here, sir, to answer any questions you might have, and if you don't have any, that's fine by me.
Thank you. So there was one hearing statement that was submitted on this topic, but to my mind, it reflected more on potential implications for delivery of some of those sites rather than the HRA itself, and that's something that we'd discussed in quite a lot of detail in July. So I've got nothing further to add on that. Is there anything specific on the consolidated HRA before we wrap up the session today?
No, sir, not from us. Thank you.
Thank you. Any others on the call? Okay, so if we could just take a brief adjournment before we move into the closing session. If we could come back at 4:25 for that. So if we could adjourn now, please. Right, so if we can resume. So this is the closing session of the hearings there. The purpose of this session is to give some indication of the next steps in the process and to deal with any procedural questions that the council may have. None of this should be taken as prejudging the contents of the final report, which will take into account all relevant matters and representations. Before we continue any further, it'd be useful to refresh on some of the actions that have arisen from today's discussion. So I've got my list here, if I can just check these with the council, please. So there's, firstly, there was a planning encyclopedia extract relating to section 203 of the Housing and Planning Act 2016. Secondly, there were the cases cited on restrictive covenants to be added to the examination library. Thirdly, there's the supporting material on other sites and neighbourhood plan allocations or emerging neighbourhood plan allocations. And finally, there's the committee report in terms of the self-build register that we've just discussed before the break. Does that accord with your notes, Mr. Begman?
So I think I got passed to Miss Knowles for this. She's been keeping her usual assiduous list.
Yes, so the only other things I had was that we were going to replace the Bidwell's note with a corrected version and highlight where the error was there that Mr. Longley referred to, and similarly with Appendix 4 to our Matter 2 statement. We'll do the same with that one as well.
Yes, yeah, yeah, that's correct. I'd missed those off, but yeah, those corrected notes as well, please.
So, and just one more that I noted.
So secondly,
beg your pardon, sir. One last one I'd noted was we were going to confirm whether the fairground site report in October was going to be a public report, and if so, add that to the documentation in due course.
Yes, yeah, I did make a note of that, but I wasn't sure how far we got on it. But yes, Mr. Longley, if you could do that, that would be useful. Thank you. So moving on from that, when is an updated draft of all the main modifications that have been suggested thus far likely to be available?
Well, so we were proposing to supply that to you within a week of today, and together, along with those changes, there will hopefully be a version of the emerging plan that will have those changes in there for ease of digestion, as it were.
Thank you. So some of the suggested main modifications may also lead to a requirement to change the borough's policies map to ensure that the spatial implications of the Part 2 plan are accurately reflected. So the council should consider whether such policy map changes are necessary and how they can be consulted on alongside the main modifications material. Have you got any views on how long that will likely to be taken, how that could be taken forward?
So I think we may need just a few minutes to come back to you on that one.
Okay, I mean that's something that we could deal with in post hearings correspondence if you need to take a view on it. But at this stage, it's just to make sure that it's on your radar, as it were.
So that's helpful. Thank you.
Okay, so in terms of next steps, in addition to the potential changes that have already been identified, following the closure of the hearings, I will be reflecting on whether other elements of the Part 2 plan are potentially unsound or not legally compliant, and whether any revisions would be necessary to ensure soundness and or legal compliance in those regards. For my part, if I were to consider that further main modifications or other work should be necessary, I will cover this in post-hearings correspondence. My intention would be that any post-hearings correspondence would be helpful and will give the council an opportunity to consider what further modifications, if any, should be made and how any further work could be progressed. The production of any correspondence of this type will be my immediate post-hearings priority, following deliberations on the discussions that have taken place and the evidence that's been submitted. My aim will be that any initial correspondence will be with the council by the end of September. Any letters from me will be publicly available and published on the website in the normal way. Following the conclusion of any post-hearings correspondence process, the ball would then be in the council's court to finalise the schedule of proposed main modifications and to undertake any further associated work that may be required. I will, however, need to see the main modifications material before it is published to ensure that it reflects my understanding of discussions held thus far and is in the interest of the soundness and legal compliance of the plan. In order to assist me in terms of my work programming, it will be useful to know whether the final main modifications material would have to be approved by council committees, and if so, what the dates of upcoming committees are and the relevant deadlines for submission of reports to them are. Is that something that you could assist me with now, or is it something that you can communicate via the programme officer after the hearing is closed, Mr. Beckman?
So I think that's something that it would be easier for us to do, certainly on a comprehensive basis through the programme officer. That's convenient.
Yeah, thank you. So just a reminder, there's a distinction between main and additional modifications. Additional modifications are those that, taken individually or together, do not have a material effect on the policies of the plan and their interpretation, and do not therefore have a bearing on its soundness or legal compliance. Consequently, unlike main modifications, my role does not extend to recommending additional modifications. Also, unlike main modifications, additional modifications need not be the subject of consultation. However, if the council wishes to include additional modifications alongside other consultation material for completeness, then the distinction with main modifications should be spelled out clearly and they should be contained in a separate schedule. The Inspectorate's Procedure Guide advises, at paragraph 6.9, that the nature and duration of the main modifications consultation should reflect that of the consultation held at Regulation 19 stage, where appropriate. So I note that in the Local Plan Part 2's case, the addendum was consulted on for 6 weeks, which is in line with the Council's adopted statement of community involvement. But the Regulation 19, the previous Regulation 19 version of the plan was consulted on for 9 weeks, in part due to COVID-related restrictions in place at that time. So just in the light of these considerations, in particular that guidance I've referred to from the procedure guide, did the council have any thoughts on what the appropriate consultation for the main modifications would be?
So I think our preference would be for the statutory 6 weeks, because there is a real urgency within the council to get this plan completed, and I believe there's also local elections next year, so we need to do so before the PERDA period kicks in with that in terms of consultation. So for various reasons, I would suggest that now COVID is hopefully over in terms of its impact on consultation, that we stick with the 6 week statutory period.
Thank you, Mr. Longley. So in carrying out further consultation, you should make it clear that comments should solely be addressed to the proposed changes and the implications arising from them. And you should also bear in mind the possible need for further sustainability appraisal and any necessary assessment under the habitat regulations. The council should keep me informed of progress, particularly the date of the close of the consultation period. Once consultation on the main modifications is concluded, I would welcome a statement from the council which responds to the main issues raised in consultation, and I will take this into account in framing my report alongside the consultation responses. At the moment, it's difficult to give definitive guidance as to when the final report will be produced, but I expect this to be early 2023 at the earliest at this juncture. So are there any procedural questions you have at this point regarding the post-hearing stage, Mr. Beglin or Mr. Longley?
So no, thank you. That's all very clear.
Thank you. Okay, so before we close the hearing sessions, I would like to invite the council to make any closing remarks they may have.
Sir, as you know, when we were here at the end of the last set of hearings, I made a short closing statement then on behalf of the council, and that's now publicly available, I understand. And so in those circumstances, and bearing in mind our audience is perhaps somewhat whittled down from what it was then, I just make some short closing remarks now. And sir, first of all, to thank you once more, first of all, for the conspicuously careful attention that you've given to part 2 of the local plan, and for continuing in your mode of providing further guidance and direction to the local authority with a view to securing that a sound plan can emerge from this examination process. And the authority is grateful for that approach. As we previously set out, and as Mr. Longley has just repeated, we consider as a council that there's a clear and compelling case for part 2 of the local plan to be put in place as soon as possible in order to secure the various benefits that it can provide in the short, medium and remaining term of local plan part 1. And it does mark an important moment in the borough's progress towards delivering on its strategic aims and ambitions. Our evidence base we have sought to maintain in a proportionate way so that it supports you without being overlong in relation to any of the matters that have needed to be addressed. We know that adoption of part 2 will allow the council to secure significant amounts of further housing to the benefit of both Waverley and Woking, an issue that we've previously discussed. And in relation to the overall tenor of the local plan part 2 being the daughter document of part 1, we acknowledge, as we did before, that of course no planning decision can satisfy everyone, and that kind of truism must apply with all the greater force to a local plan which makes substantial provision of the kind that part 2 does, because it necessarily seeks to strike a balance between the various important planning considerations that emerge. And that is what led the council to undertake the substantial public consultation that it did to inform its plan making process. And so you've just indicated how that process of consultation will continue into the future with a view to the adoption of a sound local plan. And so we welcome those opportunities to continue to progress part 2 in light of your further guidance with the main modifications that are considered necessary. And again, we're grateful for your indication about how quickly you envisage that you'll be able to respond to the council. And so, sir, our thanks for all of that, and our thanks once again to the programme officer, Charlotte Glancy, for the support that's been provided throughout. And again, perhaps even more today than on previous occasions, to the technical support team for ensuring that today was able to progress just as smoothly as it did. So, sir, thank you. And I wish everyone who's attended today a good and, as I say, straightforward week. It's not a Friday this time round, but hopefully the remainder of this week will still be a little more straightforward for those who have attended today. Thank you, sir.
Thank you, Mr. Beglin. So finally, I would like to thank Charlotte Glancy for the efficient and effective work she has done and continues to do as programme officer on this examination. I'd like to thank the council for their timely responses to my various requests. for accommodating these sessions both virtually and in person, and for their positive and proactive contributions during the hearings. And I also thank all representatives who participated for their input, engagement, and solution-oriented approach to the discussions. So the hearing sessions are now closed.
Thank you, sir.